Please be seated. We have one case on the calendar this morning. This is a special setting. The case is Department of State, Division of Elections versus Martin. Before we begin, I have two announcements I'd like to make. The first is, on behalf of the panel, I would like to commend all of the parties, including amici, for the uniform high quality of the briefs that were prepared, notwithstanding the constraints both in terms of time and length that you were forced to work within. The second is that we have decided we're going to allot 20 minutes per side, and if it seems like we need more time than that because of questions, we'll be happy to give that to you. Okay, we'll hear from the appellant.
Good morning, Your Honors. May it please the Court, I'm John Glogow, Attorney General's Office, on behalf of the Department of State. With me at the table is Sharon Larson from the General Counsel's Office. I'd like to reserve 5 minutes, if I might, for rebuttal.
Okay, you know how the clock works.
Yes, sir, I do. Your Honors, this case involves the attempted withdrawal of a candidate from the District 22 congressional race, which is in Broward and Palm Beach counties. The Department of State received the official letter under oath from the candidate that's required by the statute on September 23rd of this year. The statute says that within 42 days of the election, that the Secretary of State, or the Department of State, I suppose it says the Department, has the discretion whether to allow a withdrawal of a candidate within 42 days. It seems to have been accepted at some point in this case that the September 23rd was 40 days prior to the election. And because of the reason that the withdrawal was denied was that the Secretary felt that it would be disruptive of the election, it needs to be pointed out that what the statute says 42 days before the election. It does not say 42 days before Election Day.
Mr. Glogow, you can make that argument if you want. I don't think it's going to get you very far. When we talk about elections in the election code, we talk about days. Early voting is not the election. It's early voting.
I certainly understand that, Your Honor. The reason I mention it is because the plaintiffs in the case have asserted that and especially in their brief, in the court below, there was an argument made about statutory construction and whether the provision in 100.111 superseded the discretion that's set forth in 101.253. I read their brief as not making that argument here, but rather making the argument solely that the discretion that is involved in that statute is an unconstitutional delegation of authority. Now, the only way our position would be that it is not an unconstitutional delegation of authority, and the reason is that if you do as the plaintiffs or the appellees suggest, and that is you sort of read the statute with blinders on and only look at the language in 101.253, certainly there are no standards in there. It simply says the Department of State may in its discretion allow such a candidate to withdraw after the 42nd day before an election upon written notice sworn to under oath. But if you take the blinders off and look at the entire election code, what you begin to see is that the code has two basic purposes. One is to effectuate the public policy that the court below recognized from the recent case involving Ralph Nader in the Black case, and that is that access to the ballot and ensuring that everybody gets to vote is an important public policy, and it certainly is. However, there's another policy that the election code seeks to effectuate, and that is that we have orderly, fair elections. Now, normally, as you're far out from the election, those two things are not incompatible. There's nothing that puts them in conflict. But certainly, as you get closer to the election, it becomes more and more important for the Secretary of State to be able to run a fair and organized election. Now, the legislature determined that 42 days out, Before that, the withdrawal of a candidate is consistent with both concepts, and the candidate has the absolute right to withdraw. Once you get within 42 days, I think we should be reading the statutes of the legislature starting to tip the balance further in favor of the policy of making sure that we have an orderly election.
Mr. Gloger, I think we'd all agree with you that there's a balancing that needs to take place here. The concern, though, it seems to me, is with the second sentence of 101-253, which appears to give absolute discretion to the department if a candidate wishes to withdraw fewer than 42 days before the election. How would a candidate know what facts would result in the department giving him or her permission to withdraw in fewer than 42 days?
Well, as I said, when you look at the election code as a whole, the necessity of running an orderly election is the guiding principle that drives the discretion that's found in that sentence.
Okay.
And when you look at the case law that's cited regarding testing a statute for whether it's an invalid delegation of authority, I think this court in the Brewer case said that whether the court can determine whether the agency is carrying out the intent of the legislature is at least part of the test, and I think is probably the test that really should control here, because I think that this court can test the exercise of discretion here by determining, if it was presented to you, and I think it is here, but do the facts in this case warrant a finding by the Secretary that the withdrawal would disrupt the election?
Is it good?
It seems to me the problem with that argument that you're trying to carry out the intent of the legislature is that, as I understand it, the Department of State has said that, well, we don't want to allow the withdrawal because if we do so, we'll have to comply with the terms of the statute for substitution of the name on the ballot. It's late in the day. That will create a lot of chaos and disruption. But it seems like that's what the legislature has required. So I'm struggling for you to help me with. You say there's discretion, and it's subject to some kind of review, and I think you would agree that there's subject to an abuse of discretion, correct?
Absolutely.
Well, it would seem to me to be an abuse of discretion if the Secretary of State says, well, if I allow the withdrawal, I'm going to have to follow the law. And that seems to me not to be a very good reason.
Well, Your Honor, it's not that the Secretary would have to follow the law. The problem with this case, what happened in this case, is Broward and Palm Beach counties are using touchscreen balloting. And the testimony in this case is unrefuted that it takes 5 weeks to reprogram these machines. 5 weeks takes you out past the time that this withdrawal occurred.
Mr. Glogow, if that's your argument, assuming that in this case the department had received notice 2 days earlier than it did, okay? Mm-hmm. You would under 101-111 have been required to immediately notify the appropriate Democratic Party officials, and they would have then had 14 days to give you a substitute, which by my count goes to October 5th, which leaves you then with fewer than 35 days before the election, but you would have had to do it then. And so if carrying out an orderly election is the only reason justifying not granting this request to withdraw, how does that hold any water logically? If it had been filed 2 days earlier, you'd have had to do it, even though the election still would have been disorderly.
Well, Your Honor, first of all, when the legislature draws a line like this one, 42 days, there's always an argument that, well, if you're 1 day inside or 1 day outside, what difference does it make?
Well, we're not talking about the line here. We're talking about the second sentence, which appears to give the department absolute discretion.
Well, as I said before, I don't think it's absolute. It has to be governed by the intent of the legislature in the overall election code.
So 2 days made the difference here.
No, it doesn't make the difference, because frankly, if you look at the testimony in this case, even if it had been the 43rd day before the election, the supervisors of election would have been in the same position.
But you'd have had to have done it.
We would have had to have done it, yes.
And in fact, the absentee ballots had already been sent out.
That's correct. The overseas ballots had been sent out. Now, the overseas ballots under the statute are advance ballots, and the concept there is that there's
a minimum of 45 days before the election.
Right, but those are advance ballots, and the statute recognizes that those may change. Even absentee ballots, the case law on absentee ballots is that if you take an absentee ballot, you take the chance that the ballot might not be exactly as you received it. Now, I suppose that we're in a situation here where the legislature has made several changes to the election code since the 2000 election, and has not changed these time frames. And, you know,
the simple solution here would be to amend 103-253 to provide for 49 or 50 days as the cutoff, and then to delete the second sentence.
That may very well be, Your Honor. Obviously, we can't amend the statute here. The legislature has to do that. But, Your Honor, at some point in the process running up to an election, it becomes incumbent upon the Secretary of State to keep the process running smoothly. The discretion that's been given here, I think, needs to be exercised in that vein, and recognizing that some of the time periods in the statute certainly are anachronisms.
At least since 1968, the Florida Supreme Court has held that in order to pass constitutional muster as a valid delegation, a statute must so clearly define the power delegated that the administrative agency is precluded from acting through whim, showing favoritism, or exercising unbridled discretion. What is there in 103-253 that prevents the Department of State from acting through whim, showing favoritism, or exercising unbridled discretion, other than its internal self-restraint?
Your Honor, as I said before, if you simply look at the language in 101.2532, you're correct. There's nothing there. I admit that.
Where do we look?
But we must read the election code. The cases also indicate that you don't have to look just at this sentence.
That's right.
You read all the statutes in pari materia, and you look for the intent of the legislature. And the intent of the legislature is to make sure that things run as smoothly as possible. We have fair elections. And the closer you get to the election, the more critical that becomes. And so at 42 days, the Secretary is, before 42 days, they had an absolute right to withdraw. In the previous statutes, as the amicus brief shows the history of these statutes, prior to this 42-day discretionary determination, once you're inside the statutory period, and it varied over the years, you had no right to withdraw at all. And so,
well, that's not entirely clear, because in the original 1895 statute that had these two provisions that are now separate statutes right next to each other in the same statute, one could have read that original statute as providing that notwithstanding the cutoff, the party still had, I think it was 5 days back then, within which to provide a substitute. So you had a 5-day window, at least arguably, even after the deadline.
well, I suppose you could read it that way, but back in that period of time, you could have simply crossed out the name of the old candidate and written the new one in, or as the statute today contemplates, rubber stamping the new name. But you can't rubber stamp something on a computer screen, Your Honor. So we have to look at the way the technology is developed and read the statute in a way that is consistent with the realities on the ground, and that's what the Secretary of State's trying to do. We're taking the realities of what's happening on the ground, trying to apply time periods that really don't mesh very well with it. And so in determining in this particular case that the supervisors of elections in Broward and Palm Beach counties being less than 5 weeks out, would have been unable to comply with the law that would have required them to change the ballots. And in fact, I know it's not in the record, but even the ballots have not been changed down in Broward and Palm Beach County. Mr. Stork's name is still on the ballot, even though the new candidate's been designated.
And please don't misunderstand us. We're not trying to imply any improper purpose on the part of the department. We understand it's just trying to make lemonade from lemons here. It's trying to do the best it can. But, you know, our job is to determine whether the statute is constitutional.
I understand, Your Honor. But before I run out of time, just to conclude this, what I'd like to just emphasize is that it is not unbridled discretion. It's discretion that is bounded by the purpose and intent of the legislature when you read the code as a whole, and I don't think that the case law prevents us. In fact, it encourages us to look at the other statutes and the rest of the code to find out how that discretion is bounded. And I've reserved the rest of my time. Thank you.
May it please the Court. As you all know, my name is Jennifer Bloom. I'm here with Mary Askros, one of my associates, and I represent the Appellees. I think you all pretty much know what the arguments are.
Ms. Bloom, are you now conceding that the amici's interpretation of how these statutes should be read is correct and falling back to the delegation of power issue?
I think that what the circuit court held was that it's an unbridled discretion, it's unbridled discretion and it's a delegation of, improper delegation of legislative authority.
Well, I think what Judge Ferris held was that she had a duty to avoid an unconstitutional interpretation, and I think that's true if it's possible. But Mr. Glogow said he interpreted your brief as indicating that you were now agreeing that the two statutes could be read together and that 103-253 provides the procedure for withdrawing and 101-111 provides the procedure for substitution if withdrawal is permitted.
Now, what I would say is that because it's unbridled discretion and an improper legislative authority, you take out that section, and then when you read the statutes together, 100-111 4B clearly lays out the procedure for what you do within 42 days of an election. The procedure is very detailed in both 101.2533 and 100-111 4B. It lays out right to, if it's within 21 days, it tells you what to do. You can it says you rubber stamp the ballots, you reprint the ballots, or you count the votes for the withdrawing candidate as counting for the replacement candidate. So, I think that where you have to start from, though, is the fact that provision in 101.2532 that they are relying upon is absolute discretion for them to designate and determine who gets on the ballot, and that is not how it's an improper delegation of legislative authority.
Well, let's assume we agree with you on that. What's the remedy at this point? And let me tell you why I ask you that. It's now Friday morning. With luck, working through the weekend, we may be able to have a product on Monday. Monday is precisely 1 week before the election. I don't think there's any dispute but that at this point several absentee ballots have probably already been cast. We have early voting, which has been going on for a week, and we have undisputed testimony that it would take 5 weeks to reprogram the touch screens. What's the remedy, assuming we agree with you here?
Right. At this point, one of the things is that we recognize we did not bring the supervisors of election into this suit. So any remedy, basically, we can't compel the supervisors to do anything. As what the statute says, you count the votes for Mr. Stork, will count for Ms. Roripaugh, who has been designated as the substitute candidate.
Well, let's talk about that. We're 1 week out from the election on Monday. Is it fair to voters 1 week before the election, and in a situation where a number have already voted, for us to say that even though you voted for one person, surprise, the person your vote's going to be counted for is someone else.
Well, I would like to say one thing on this is that Mr. Stork withdrew on the 23rd. They knew about it on the 22nd.
I understand all of that, but we're talking practicalities
right, and
now.
Practicalities, well, it's what the legislature has provided for. It says you can count the ballots for the other candidate. I mean, otherwise, voters are casting a ballot for a candidate who will never take office.
Well, Ms. Boyman, it says when you get to count the votes for the other candidate, it says that occurs if the vacancy occurs less than 21 days prior to the election. When did the vacancy occur?
Well, I mean, of course, we would say the vacancy occurred when they should have been reprinting the ballots before the 21 days. But actually, it was right at the 21st day is when the stay was lifted and someone else was designated. So it was right there at October 12th.
So the stay was lifted on October 12th?
Mm-hmm.
And that is the 21st day?
Yes.
So this section does not apply, does it?
It's quite a quandary we're in on this. And, I mean, the legislature has laid out a process. What they're trying to do is rewrite it.
But Ms.
And that's
assuming Mr. is it Stork?
Yes.
Assuming he remains on the ballot, as he is right now, as we speak, and he should win, and remains adamant that he doesn't want to serve, isn't the solution then just to call a special election?
Right, you would call a special
so
election.
how have your clients been harmed in that situation?
Well, I think then you have the other side has another chance to run again. They lost one time. Now maybe they can put up someone else who has a better chance of winning. Here they have.
Well, they've got an incumbent now. Who are they going to bring in? President Reagan is no longer with us.
Of course. And I understand that, but I do think that this process is there, and it has to be administered fairly, and it has to be as the legislature said. Now, I mean, granted, the legislature needs to go back and look at these statutes, but they haven't, and it's not our duty or the department's duty to rewrite them. It tells you what to do. It tells you what the procedure is, but then in this one statute, it gives unbridled discretion to the department to say who can get on the ballot. And you know, I mean, this is a big, just recently in the Black case, the Supreme Court made a big, reaffirmation that ballot access is very important and that the voters should be able to cast their ballot effectively.
Well, but are they going to be able to cast their ballot effectively if they've already voted for one person and we allow you to substitute someone else?
Well, they are voting for a person who can actually take office. I mean, right now, they're not.
But it may be somebody they wouldn't have voted for had they known that was the person.
Yes, and I mean, it's a difficult situation. And again, I think the legislature, it has to be, they put out the procedures, and unfortunately.
A strict compliance of these statutes would require the Secretary of State to substitute the names, right?
Yes.
To comply with that subsection 3.
Right.
And then strike out the name of the current candidate and insert the other. They're saying from a practical standpoint that's an impossibility. So what do you want them to do? What do you expect them to do?
Honestly, we know that we can't compel anything. This race, it's not going to happen because of the time and the fact that we didn't bring the supervisors of election in. We understand that. But it's still,
is that issue really before us, or is it is it a more narrow issue? Can the Secretary of State not allow the withdrawal and the substitution by the Democrat Party? Is the remedy really before us here?
Well, I think the remedy is, I mean, what she ordered, affirming the circuit court's order, I mean, sets out what the remedy is. As far as whether it's going to be complied with or can be complied with is another matter, and the person who has to comply is not a party to the, so, I mean, in the end.
Judge Ferris, in essence, has, in her final judgment, entering the permanent injunction, has ordered the Department of State to substitute, well, to notify the Democratic personnel, and then at the appropriate time, I take it, to substitute the name the Democrats give them. And that's a physical impossibility now.
Right, but actually, I mean, if you read 101.2533, it's the supervisors who has to actually do the name change. It is, I mean, this is a case where it's very difficult to determine what needs to be done, but the legislature has said you've got to do it.
Well, all we can do is direct the department, assuming we agree with you, to do whatever they're supposed to do, which I take it is simply to notify the supervisors of elections to do something.
Right.
And then the supervisors of election, because they're not parties here, can just tell them, take a hike. So all we would be concerned about is what we have to tell the Department of State.
Right. And that is the unfortunate situation here. I mean, again, when you get back to it, I mean, if they hadn't, it was on the they knew about this on the 41st day. It was the day after they knew that this person was going to withdraw. They didn't do anything. And then they waited 6 days even after they got the withdrawal before they even notified him that he wasn't going to be able to withdraw. I mean, I think that this 11th hour also has to be laid on them as well. This is not just that Mr. Stork, who did withdraw because of health problem, was just, and that's another thing is they do this, that it was between the voluntary and an involuntary action.
Oh, I don't know that we have to assign fault to either party.
Right.
We're just concerned about a practical question, which is, assuming we buy your argument, you've worked here, you know we have to write the opinions, and we need to know what to say in the opinions. And we need to know from the litigants what the remedy is they want.
And the remedy is that we are allowed, that the Democratic Party is allowed to substitute its candidate, and that the department go to the supervisors and tell them that they have to follow the law. Whether it's done, whether it can be done, well, that's, that's not much else we can do on that.
Let me ask you, in the Constitution of the United States, in Article 1, Section 5, it says the House of Representatives shall be the judge of the elections, returns, and qualifications of its own members. What effect, if any, does this provision in any other federal law have on this issue?
Well, I don't think it has any. I think that this is a purely state law question. I mean, I think that what the department is going under is purely state law, and honestly, nothing in the federal was ever brought up by either party in any of this.
Well, surely that provision in the Constitution at a minimum means that should you be permitted, you being the Democratic Party, be permitted to substitute a candidate, and that substituted candidate should be declared the winner of the election, the House of Representatives could refuse to seat him or her.
And I guess we'd have to cross that bridge.
Then you'd have a federal problem.
Yes, we probably would. But as it stands now, this is purely a state issue, and what we have is a statute that gives just absolute discretion to the department to determine when someone can withdraw. And
you're not aware of anything in the congressional record or the House of Representatives rules or anything like that that addresses this issue?
No, I'm not. But again, I mean, it's our position that, there's substantial case law that, you have to set minimum standards and guidelines if you're going to delegate legislative power. In this case, there's just no standards. There's no guidelines. And they want to look at the entire election code. Well, if you look at the entire election code, what deals with withdrawals is 100.111.4b and 101.2533. And it lays out a detailed process on how you substitute a name within 42 days. You can't just ignore ballot access and say that, that orderly elections is all there is. I mean, the legislature obviously thinks that you can have an orderly election and have ballot access by the process they've laid down in 100.111.4b and 101.2533.
Well, but being realistic here, as a result of the 2000 election, the legislature has every session since tinkered with some portion of the election code. And it's going to take a while to get all of those provisions back into sync with each other.
Right. And I mean, I think that's what this case does. It brings the attention is that this statute, as it is written and how it has to be applied, might not be practical in what the way the voting technology is today. But I mean, the answer to that is go to the legislature, make them change it. Like you said, they take that out, put up a higher date. I mean, there are, ways around, but unfortunately right now we're stuck with this.
My guess is this is the only time this problem will arise.
Probably, because I mean, this obviously is now going to have to be addressed. But, this is an important issue as far as, I mean, it's voting, and this is an election year, and how it is with 2000 now this year. So basically, we just hope that you affirm in the circuit court. I think the circuit court's order pretty much lays it all out.
Thank you, Ms. Burke. You have just under 5 minutes, Mr. Burke.
Thank you, Your Honors. We recognize, I think, and the court has certainly recognized that the legislature needs to do something about these statutes. But we also have to recognize that if the statutes don't work, that the discretion granted to the Secretary of State here is exactly what's needed to make things work. And she is then directed by the code, as I said several times in my initial argument. It's the intent of the code that governs her discretion. In the most recent case that the Florida Supreme Court has issued regarding this delegation issue, the Bush versus Shivo case, the court recognizes that the legislature can transfer subordinate functions to permit administration of legislative policy by an agency with the expertise and flexibility to deal with complex and fluid situations. Certainly getting an election off the ground is a complex and fluid situation. It says minimal standards and guidelines, citing the Askew and the Avatar cases.
Well, Mr. Glogau, let's get to the meat of the coconut here. What would there be with the present state of 101-2532 that would prohibit a mean-spirited partisan Secretary of State from arbitrarily refusing to ever grant permission to withdraw in fewer than 42 days to opposing party candidates, but always grant them to candidates from the same party?
Well, Your Honor, I think that what I said before is in terms of whether it's an abuse of discretion. If I'm a candidate and I try to withdraw and I'm of the opposite party from the Secretary of State and she says no, and Ms. Larson over there on the same day is a candidate from the other party and she says, well, yeah, then we're before the court, probably the circuit court, and what we have is a clear abuse of discretion unless there is evidence presented in the record that justifies one or other or both, hopefully, of the decisions. In this case, the only testimony in the record justifies her decision. It's impossible for the supervisors of election to comply with the requirements that would have kicked in had she accepted.
But it would have been equally impossible to comply had he filed it timely 2 days earlier.
Oh, that's right. But in that case, the legislature hasn't.
Why isn't that an abuse of discretion?
Well,
if they couldn't comply either time, what's the difference?
Well, because there is no discretion before 42 days. The legislature has said before 42 days, tough. But after 42 days, the secretary has the ability to prevent the disruption of the election by saying no.
Even though no greater impediments will be faced.
Your Honor, let's remember that 42 days was instituted, that part of the statute was passed in 1985. I clearly would agree it has to be changed. But since it's still there and it is an anachronism, we recognize that if it was the 43rd day, the supervisors probably would still not have been able to comply, but the secretary would have been constrained to do what the statute told her to do. But once you're into the discretionary period, then she can help the supervisors of elections and say to them, all right, you're telling me you can't do it? All right, I'm not going to let it happen. Does it have to be changed? Certainly it has to be changed. But the way the statute reads now, at least if it happens within 42 days, we can prevent some of the disruption. If it happens outside the 42-day period, the Secretary doesn't have the discretion to prevent it. And that's why the statute is not unconstitutional, because there are standards, there is an intent that you can glean from the entire statute. Again, in the Shivo case, the requirement that the legislature provide sufficient guideline also ensures the ability of meaningful judicial review. And I submit that you can have meaningful judicial review here. If there's been an abuse of discretion, if what she has done doesn't further the goals of the election code to have fair and organized elections, then you strike her decision as an abuse of discretion. I don't think that there's been an abuse of discretion here. We've argued that in our brief. But there is a standard which this Court can use to test her decision, and that is really the sine qua non of the test of whether there's been a delegation or not. In the Shivo case, the law that was under attack there, it existed in a vacuum, and there was no place else to look for standards. Here there are. Thank you, Your Honor.
Thank you all. Your arguments have been most helpful to us. We'll be in recess.